Hey guys, my name is Anthony Bandiero, attorney and senior legal instructor for Blue to Gold Law Enforcement Training, being another webinar. I am broadcasting from my hotel room in Pierre, South Dakota, where I'm doing training here this week. Welcome to Good Faith in the Fourth Amendment. I really hope you get a lot out of this. Please just keep in mind that you can share this with anybody you want. There's no copyright on this stuff. Just share it, turn it into a home DVD, and make money on it too, right? And so, also, if you're interested in bringing us out or any other training and you want to talk about getting our books or hosting us and so forth, why don't you reach out to us at training@bluetogold.com. Also, realize that while I'm talking, there is a live chat going on with hundreds of officers around the nation, and they're asking questions, making comments, and so forth. So that's what we do. We do have a lot to cover. I want to kind of dive into this. There's going to be a lot of information coming at you. The agenda today is good faith. Bad faith, even though courts don't call it bad faith, but I'll talk about that. And then warrantless criminal investigations. I want to see if there is one particular person here. Okay. Okay. So, okay, cool. Let's continue. So, and then we're going to talk about pretext stops inventories. All right. So, good faith. Now, I will tell you that good faith is one of the more misunderstood doctrines out there, because what a lot of cops think is that they think that if they do something unlawful, right, unconstitutional, right, not criminal, right, but unconstitutional, a lot of them think that if they did that activity with good faith, meaning they thought they were doing the right thing, but the court said it was unconstitutional, that they cannot be sued, right, and that they will win. No, it's not. That's not the definition of good faith, right? So that's not good faith. Good faith is when you are, depending and relying on something outside, your decision-making process to help you decide what you're going to do, like a search warrant, an arrest warrant, and so forth. If you do something warrantless and you make that decision on your own, it's not good faith. It's objective reasonableness, and you're going to have to look for qualified immunity on that situation. So I think the seminal case here, I don't think, I know, it's United States versus Leon. It's a case from 1984 involving a situation that happened on Price Drive. So essentially what happened here is in 1981, Burbank police officers initiated an investigation based on information from a confidential informant that Armando Sanchez and Patsy Stewart were selling drugs from their residence, okay? Now, this led to a series of observations and checks linking these suspects to drug trafficking operations. Now, the police obtained a search warrant for several occasions, including 620 Price Drive. The searches yielded a substantial amount of narcotics. Now, the problem is that, the police did not really vet the confidential informant. They did not corroborate the confidential informant, but they did get that warrant, right? And that judge, based on what that judge saw, signed off on it. And the court, said, look, okay, even if, right, even if we're going to, we have issues with this warrant, the exclusionary rule, right? The reason why we exclude evidence against a suspect is to deter police misconduct. We do not want you to be going out there like training day and kicking down doors and violating people's rights and using Chinese menus to go search people's drawers for their cash, and then reward you for getting their drug money if you turned it in, and reward you, for your misconduct, right? That's not fair to anybody. And, if the Fourth Amendment does not, according to the Supreme Court, this is what they said, if the Fourth Amendment does not penalize that, then there's no teeth in the Fourth Amendment. That's for another day, right? Whether or not the exclusionary rule is something that's it's maybe legislating from the bench, right? But the Supreme Court said the deterrent purpose of the exclusionary rule necessarily assumes that the police have engaged in willful, or at least the very least negligent conduct that has deprived the defendant of some rights. By refusing to admit evidence gained as a result of such conduct, the courts hope to instill in those particular investigating officers, or in their future counterparts, right, for law enforcement in general, a greater degree of care towards the rights of an accused. Where the official action was pursued in complete good faith, however, the deterrence rationale loses much of its force. So why are we punishing police officers for doing exactly what the courts sometimes want you to do, which is go ask a judge for their permission to go search or seize? And if you depend on that warrant, that is good faith. So really good faith comes in three flavors. Defective warrants, invalid arrest warrants, unconstitutional laws. Let's talk about defective warrants, right? Because that's what happened in Leon. Leon was a defective warrant, right? Because they didn't vet that CI, and there were some probable cause issues. But good faith applies when officers reasonably rely on a judicially approved search warrant, though in some way defective. Now we're going to talk about this bad faith. There's a line that you can't cross, right? You can't lie on your warrants, and you can't, be reckless with the facts and so forth. But Massachusetts versus Shepard is your seminal case in this case, in what happened here. So in 1979, the police found a body of a victim in a vacant lot in Boston. Now, showing signs of violent death, they soon focused on the defendant, her boyfriend. Evidence included bloodstains and hair matching the victims were found in a borrowed car that the defendant used. The detective prepared an affidavit to obtain a search warrant, but here's the problem. He used the wrong form. The form that he used for the warrant was really for narcotics. It wasn't for murders and so forth. Now, the judge said that, he would make the changes, he would fix it, he would cross out stuff, but he didn't cross out stuff that was supposed to be crossed out. But was that good faith? Should we penalize these officers for that? And should we suppress all the evidence of the murder because of that mistake? And the answer is no, right? So, as the court in Shepard said, the police conduct in this case clearly was objectively reasonable and largely error-free. An error of constitutional dimensions may have been committed with respect to the issuance of the warrant, but it was the judge, not the police officers, who made the critical mistake. The exclusionary rule was adopted to deter unlawful searches by police, not to punish the errors of magistrates and judges. Judges get a little leeway because they are the judge and the buck stops there, for the most part. You also have a case called U.S. versus Jackson. This is not a Supreme Court case, but a case out of the Eighth Circuit. What happened here is Jackson probably committed the cardinal sin of a felon in possession of a firearm. Okay, so he gets his gun stolen. Okay, and his nephew steals the gun, and the reason why the nephew stole Jackson's gun was because Jackson was threatening him with it. Right, he was about to assault him with the firearm. I mean, so he yanked the firearm out of Jackson's hands and he took it, and Jackson called the police, right? And he says, my nephew stole my gun, and they look up Jackson, the guy's a felon, right? So they go to the nephew, and they're like, hey, you stole Jackson's gun? It's like, yeah, he was about to kill me with it type stuff. And he says, just so you know, Jackson has more firearms. The one I stole, in self-defense, really. The one I took is not the only one. He has another gun, described it, and so forth, in his closet. And, so they go to, they write a warrant, and they go serve it. Now, he said that the warrant lacked probable cause, right? But a judge signed the warrant. So the question in Jackson, and just so what happened in Jackson was that the officer did not put all the information about the firearm and why the nephew thought he had more firearms in the warrant, okay, in the affidavit. So the judge was asking him more questions about that, about that probable cause, and the judge, based on the information that he got verbally plus information in the affidavit, signed the warrant. The problem is that information never got into the warrant. And he said, Jackson's like, hey, look, this is facially invalid, right? Because everything else you guys have talked about, outside this affidavit, it's not in this affidavit. But the judge remembered, okay? The judge remembered his conversation with the police officers. And he says, no, look, I asked about that. He did mention this and that. So the court upheld it as good faith. However, just as a side note, Jackson works out because because the judge remembered that conversation. If the judge forgot the conversation he had with the police officers, it would have had a different outcome. We find the actions of the deputy in executing the search warrant were taken in objectively reasonable good faith, considering the deputy's knowledge and actions. The review and approval of the warrant application by the prosecutor and the issuance of the warrant by the judge after the deputy responded to his specific questions. I'm glad it all worked out. But I guess my little pro tip here is please make sure that everything that you need to be considered in the warrant is in the affidavit. Um, I think it is a Missouri case. Are you familiar with this case, Sean? Is that something that you're right? Because it's maybe did it involve you, Sean? Oh, okay. Did you forget to write a good affidavit like I taught you? Now let's talk about U.S. versus Cruz, a case out of the 10th Circuit. Basically, what happened here is the defendant was convicted of possessing methamphetamine with the intent to distribute. The conviction was based on evidence obtained from a search of his residence under a warrant that was not signed or dated by the issuing judge at the time of execution. So this is defective under state law, right? The judge must sign the warrant in order to be valid under state law. That makes sense, right? How do we know the judge approved it if the judge didn't sign it? Now, the judge actually, if I remember correctly, he signed the affidavit, right? In other words, I think he made like a mistake. He wanted to sign it, but he didn't sign it correctly. Maybe it was like 2 o'clock in the morning. He was half asleep and so forth, right? But should we penalize these police officers? Should we suppress all these drugs because the judge was half asleep and signed the wrong piece of paper? The answer is no. Okay, that is classic good faith. Look, don't get me wrong though. Okay, if you have an officer out there that catches it, oh, Your Honor, please, before I leave, can you please sign the actual warrant? That would be awesome, right? But a lot of cops are a little nervous, around the judge. They don't want to second guess the judge. They thought the judge did it correctly, and they just kind of go off and do their thing. That's okay. We're human beings, right? So the officers who searched Cruz's home would have been entitled to the Leon good faith exception to the exclusion rule. Kennedy's failure to file a motion to suppress did not prejudice Cruz. That's something else. Okay, so I also want you to know that some states do not fully recognize the good faith exception. Their viewpoint is that, hey, if you don't have a valid warrant, it ain't valid, right? Under the state constitution, under our state rules of criminal evidence, it's on you. But, most states are fine. I mean, you can kind of see a mix of red and blue states on this issue, but a lot of this comes from the blue states where they think that it's just somehow unfair to the defendant. The next thing I want to talk to you about is invalid search warrant, arrest warrant. So we have a search warrant. It's pretty much going to be valid as long as, you did your job, you went to the judge, they approved it, right? Now let's talk about invalid arrest warrants. Good faith also applies if you arrest somebody, but learn later that the arrest warrant was actually supposed to be pulled and so forth. So our seminal case here is Arizona versus Evans. What happened here is the cops stopped the suspect for driving wrong way. They discovered his driver's license suspended, but there's also an outstanding warrant for him. Now they probably could have arrested him anyway for the driver's issue, but ultimately they're arresting him for the warrant. Okay. When they searched his car, they found marijuana, and they later found out, after they, take him to jail and so forth, was that warrant actually was canceled 17 days earlier, but the system wasn't updated. Now, should we penalize these cops, right? Should we take their hand and just boom, slap it and say, hey, why are you guys violating people's rights out there? Or should we actually turn to, somebody else and try to, figure out why the hell that warrant was not pulled out of the system? And that's good faith, right? That's good faith. In other words, you cannot deter police misconduct by suppressing this evidence, because every cop in America is not second guessing the warrant system. They're doing exactly what we expect them to do. Now, this is what they said, and it makes total sense. If it were indeed a court clerk who was responsible for the erroneous entry on the police computer, application of the exclusionary rule could not be expected to alter the behavior of the arresting officer. As the trial court in this case stated, I think that the police officer was bound to arrest. I think he would have been derelict in his duty if he failed to arrest. And that's exactly right. So there is no, remember, why do we have the exclusionary rule? To deter police misconduct. Another case that's kind of similar to this is this cop who looks like he's watching porn while at work is Herring versus US, right? So this is whole, you see his whole body language, the AI body language. It's like, hey, I got nothing else to do, right? So what happened here is a guy was arrested in 2004, and it was based on this neighboring county's database that there was a warrant for his arrest. Now, it basically was like what they call a pickup order, right? Right, kind of like a pickup order. So pick him up. We have PC, that type of thing. It was later recalled that discovered that this warrant was recalled this pickup order and so forth. And again, we're back to Evans, right? The information was not pulled from a computer. I don't know why we really need, quite frankly, I have to look into it more, but I'm not sure why the Supreme Court actually took this case. I don't know why they just didn't tell Herring to look at Evans and figure it out for yourself, right? But the point is, good faith applied. It's another good faith case. As the court said, to trigger the exclusionary rule, police conduct must be sufficiently deliberate that exclusion can meaningfully deter it, and sufficiently culpable that such deterrence is worth the price paid by the justice system. I see. So you see what Zach says. So Zach is saying one is judicial official, the other is by law enforcement. Good. I appreciate that because they both are good faith, but different sources. Thank you. All right. The next thing is unconstitutional laws, right? So that's another kind of like good faith thing, right? You are allowed and expected to enforce laws as written. And if they later prove to be unconstitutional, why should you be penalized for that, right? And there's no deterrent value. Now, there is a case out there that I don't have in this slide today, the presentation today, where you can get a little extreme with this, right? There can be some laws that are so facially unconstitutional, right? That that a reasonable police officer, should realize that they're unconstitutional. I don't know. I'm a gun guy, so don't listen to me at all about what I would do. But this whole thing about the AR-15 not being protected by the Fourth Amendment or Second Amendment is such BS to me. Like it's so clear to me that the AR-15 is a semi-automatic rifle is clearly protected by the Second Amendment, right? Otherwise, this is a musket society, right? So, when I see cases like the Fourth Circuit and you have all these crazy gun laws, I don't know. I couldn't in good conscience enforce some of them, but I'm also I have a forte in this a little bit. So, but sometimes, it's so clear, right? Now, this is a case. I love this AI pick, by the way. I think it's just fantastic. It's like some of these AI picks to me are pieces of art, and this is one of those pieces of art. So what happened here is that the Illinois state passed a law that basically allowed like unfettered warrantless searches of junkyards, right? And junkyards are considered, highly regulated activities. There are some things that we can do to them that we probably couldn't do to the 7-Eleven as far as our warrantless search activity, because they want to find the stolen cars, right? And so it involved 1981 in this case, Action Iron and Metal, and it was a wrecking yard. And so the police found several stolen vehicles and maybe like a chop shop, and later the federal court found that law as written was facially defective, right? It gave too much discretion to police officers to do these warrantless searches, and they said it was unconstitutional. Now, the problem is, right, at the time, should these cops really know that this was not constitutional, right? I mean, is it really so obvious to everybody in the room, a reasonable officer, that it shouldn't be, we shouldn't even be using this law? And the answer is no, right? A statute cannot support objectively reasonable reliance if, in passing the statute, legislature wholly abandoned its responsibility to enact constitutional laws. Look at, again, you want to go to gun laws? California is full of these BS, laws. I think they don't even care about the Second Amendment, right? But still, I'm a little extreme on that. Nor can a law enforcement officer be said to have acted in good faith that the statutory provision they relied upon was such that a reasonable officer should have known the statute was unconstitutional, right? But that's pretty extreme. However, though, in that case, I didn't put the quote in there, I should have. In that case, it was reasonable to believe that the statute was constitutional. Another case involving some cops in Michigan, they were called about a person, called about intoxicated individuals, found the defendant and a woman in an alley. When questioned, the defendant initially claimed to be a police officer, then changed his story. He failed to produce ID when asked, violating a Detroit ordinance, right? That required individuals to identify themselves when stopped by police. So this was really like the ultimate stop and ID law, right? That is, stop and ID statutes have been upheld when there's reasonable suspicion, and especially when that ID can help you solve that crime, right? But this is like the way that this law was written. It basically said that if I can be stopped by the police, and just for no reason, essentially, and demand my ID, and that is obviously unconstitutional, right? But again, police are charged to enforce laws until and unless they are declared unconstitutional. The enforcement of the law forecloses speculation by enforcement officers concerning its constitutionality, with the possible exception of a law so grossly and flagrantly unconstitutional that any person of reasonable prudence would be bound to see its flaws, right? So we can have an argument what those laws are, but again, that's what where we're at, okay? So this doctrine also applies to case law that is later overturned by the U.S. Supreme Court. That is something that you will see all the time, right? You'll see a cop search something, do a search or seizure based on existing case law from a binding court, their Circuit Court of Appeals or their Supreme Court. Then that gets overturned, rarely, but it does happen. That law will get overturned. And then what happens to that case that they did under the law at the time, right? Usually they're not going to suppress the evidence, right? U.S. versus Matson is probably a really good case on this point, where officers basically arrested somebody. I don't have to read all this, but they arrested somebody. They then did a search instant to arrest the motor vehicle. This is kind of like the Belton rule, right? Where cops would just routinely, search these vehicles as a matter of routine without having any articulation of the person being near it or something like that. And which one is that? And so, the court, at the time of the search into arrest of the vehicle, the cop was acting under then binding authority, right? This Belton rule and so forth, until the Supreme Court clarified that in Arizona versus Gann. The search of Matson's vehicle falls within the good faith exception to the exclusionary rule, right? The good faith exception applies here because the search of Madden's vehicle was objectively reasonable as a search instant to arrest, right? So excellent, right? Okay, bad faith. Now, the courts don't use the phrase bad faith. That actually comes from Wayne LaFave, who is the godfather of search and seizure, right? He kind of talks about like this is like almost like the bad faith exception, right? Bad faith rule and so forth. Now, good faith doesn't apply if a reasonable officer would know the warrant or that the warrant or statute was obviously lacking legality, right? So again, we kind of talked about some of these issues: lies and reckless information, biased judge, facially invalid. Let's kind of get through this. So the first one is facially invalid. That's probably your most common one, that that the defendant will try to attack the search warrant. They'll say, look, it's and that facially invalid, but also the lies, right? It's the cop lied in here. They put information up. They said that my client had this criminal history that contributed to probable cause, but that's not him. That is some other guy that they must have been talking about in a previous search warrant. They must have used some template search warrant. Well, the standard is reckless or, reckless with information or lying, right? So, State versus Mason. So, what happened here is the defendant was charged with promoting prostitution, child exploitation, possession of marijuana, following evidence obtained from a search of his residence. Now, the police secured the search warrant based on an anonymous tip about this defendant involved in sexual activities of underage girls. The commissioner issued the warrant based on the probable cause affidavit, which include the surveillance details and confirmation of the defendant's identity, and vehicle and so forth. So, look, this summary could be better written, but essentially, they're getting this warrant off this anonymous tip, right? And generally speaking, we don't get warrants on anonymous tips, right? We need to corroborate, we need to put more in there and so forth, right? So the court said the exception does not apply where the warrant is based upon false information knowingly or recklessly supplied by an affiant, or if the supporting affidavit is so lacking in indicia of probable cause as to render official belief in its existence entirely unreasonable, right? So our Supreme Court has emphasized that corroboration of inculpating information can sometimes be crucial to determining the existence of good faith. So the cops did just not do enough in that case. Okay, so biased judge, right? Biased judge. So good faith doesn't apply if the judge wholly abandoned his judicial role in issuing this the search warrant. There is no Zach, you know you love this case. I love this case. This is some funny ass stuff right here. Okay, Logi Sales Inc. New York. Okay, so what happened here? I love this case. It is so damn funny. So this judge gets an affidavit for pornography. Okay, so the cops come in and they say, look, the Logi Sales is like selling pornography. Pornography in 1970s is like probably kids cartoon magazines of 2024, right? Or at least the stuff that some people want to put into the elementary school bookstore. So, library, right? So, the judge wants to, he says, I'm gonna issue the search warrant, but I'm going to go with you to review the pornography to confirm whether or not it violates state law. And I'm sorry, do you think there's an ulterior motive here? Do you think that this judge is maybe not getting what he needs at home? Why the hell would he think it's appropriate for a judge to do a ride along with the police to go, look for some smut, right? I mean, is he doing that with the drugs? Is he going there and saying, I want to make sure that you find real cocaine and methamphetamine? No, I think he has an ulterior motive, and you can't blame him, right? You can't blame him. So the court said the town justice did not manifest that neutrality and detachment demanded of a judicial officer when presented with a warrant application for a search and seizure. He allowed himself to become a member, if not the leader, of the search party, which was essentially a police operation. It is funny. Guys, please also, Teresa just put up there some social media links. It really means a lot to me because I get alerts when you guys sign up, for YouTube and Instagram and so forth, whatever tickles your fancy, how you get your social media information. But please, we work very hard to get you guys some good information. So please sign up for that. The next thing is facially invalid. Okay. So it's just a way of looking at this, right? So good faith doesn't apply if the warrant was so facially deficient that no police officer could have reasonably presumed the warrant to be valid. That's where, you look at this damn warrant and you read the affidavit and you're like, dude, there is there is no probable cause here, right? Has anybody on this webinar read a warrant that's been issued by a judge and then you said to yourself, no way, this ain't probable cause, I ain't doing it, bullshit, right? So, the OnlyFans account, they'll definitely drive away some business, That's awesome. So, this is an example of a warrant that really was just so facially invalid that the court just threw it out. It's talking about getting permission to search and seize for all correspondence, telex messages, contracts, invoices, purchase orders, shipping documents, payment records, export documents, packing slips, technical data, and on and on and on, that somehow can violate the illegal exportation of materials in violation of Arms Export Control Act. The problem with this is that, it didn't give the officers enough guidance, okay, to determine if this contract should be seized versus this invoice. It's too damn much. It's basically, the court basically said, look, with this warrant, you can seize the whole damn corporation. Like, you can just take everything from their inventory and from their offices, because that's what the warrant is allowing you to do. It's too much, and they're going to suppress it, right? It was so facially invalid. We find the warrant so facially deficient in its description of the items to be seized that the executing officers could not reasonably rely on it, right? Okay. Now, before we go on here, I want to kind of remind you that warrantless criminal investigations we don't really use good faith there. That's not what we use when it comes to warrantless criminal investigations. Now, this is ultimately, at the end of the day, all of this is fundamentally built upon objective reasonableness, right? They call it good faith, but, are you being objectively reasonable by executing a search warrant where the judge forgot to sign the right piece of paper, right? Are you being objectively reasonable by executing a warrant that the judge says, 2023 instead of 2024? Of course you are, right? But when it comes to warrantless searches and seizures, we don't use the phrase good faith. We just say objectively reasonable, right? Because you are the one making that call, right? You are the one deciding whether or not you have what it takes to do that warrantless search and seizure. As the Supreme Court said, good faith, this concept of good faith is outside telling you to do something, is incompatible with objective reasonableness. Therefore, the focus is not on good faith, but on whether or not the law was clearly established at the time. So they're talking about qualified immunity, right? When it comes to doing the right thing and so forth. And you just have to know the law, right? And you got to go to our classes. You got to go to Zach's classes. You got to go to my classes. You got to go to Nick's classes. You got to go to, all these people, because we're here to teach you the law, right? So let's talk about, when it comes to good faith and, objective reasonableness, I just like to talk about pretext stops. Remember, pretext stops, are objective reasonableness. Can you objectively make that traffic stop? I like to say that, most traffic stops, in my view, I think most are pretext. I think most are, especially at the the municipal level, the sheriff's department level, people that are not assigned to traffic, like highway patrol. I think a lot of them, are like looking for other criminal activity, and they're hoping to get into something, right? But, it's not, would you have, it's could you have. Could you have made that traffic stop? Does the law allow it? It's not would you have. There's a lot of traffic stops that I would never have made if it wasn't for my ulterior motive. But it's not the question of would I've done it, but could I? And the seminal case in this space is, of course, Wren. Basically, what happened is that, Wren was a narcotics officer in DC. He thought that Wren was up to something, and some kind of narcotic activity, and he uses a pretext. He actually finds a reason to pull him over, but it's pretty clear from the evidence that it's pretty clear from the evidence that the cop would not have pulled him over if it wasn't for this pretext. You also have to remember that this is the early 90s, right? The wound of Rodney King is very fresh, right? The nation is still trying to heal over that, and people are concerned that pretext is also a gateway for racial profiling, and we all understand that, and we condemn it, right? But the Supreme Court is saying, look, at the end of the day, there was no evidence that Mr. Wren was pulled over for his race. He was pulled over because this officer thought that maybe something else was going on, but he had a reason to pull him over. And he didn't, this is a different issue, but he also didn't extend the traffic stop for an unlawful, for a different reason. He just did a traffic stop, and he saw evidence in plain view, and they went from there. Okay. Another thing that does, okay, so Zach actually kind of mentioned that there's different definitions of good faith. I'll tell you, here's another definition of good faith. Inventories. You have to be on the up and up on these inventories. Inventories require, actually, when you think about good faith, right? When you think about like what good faith kind of sounds like to you, what it means like conceptually, that's what we're talking about here. Like you have to, when you inventory a vehicle, when you tow a vehicle, right? You have to, you have to be on the up and up. Your brain has to match your hands, right? But when it comes to criminal investigations, your brain doesn't have to match your hands. As long as you're doing the right thing, you're making the right stops for the right reasons, and you're not, of course, racial profiling it violates the Constitution. As long as you're doing the right thing, it doesn't matter what's up here. It just matters that you do the right thing, but not with inventories. Your brain has to match your hands. So the reason why, and one of the reasons is that if the courts allow a inventory to be a subterfuge for a criminal investigation. In other words, you just find a reason to tow the car and find the drugs. It short circuits the probable cause requirement, right? You don't need probable cause if you can just tow it. And the courts don't allow that, right? The courts don't allow that. And so it really all starts with a case called Opperman. In a nutshell, speaking of, I'm in South Dakota right now. I should go visit. Maybe they have a museum in Vermilion, South Dakota, of the car that was towed by the officer out there. So Opperman's car was towed for parking violations. And while they did their inventory, they found drugs in the glove box. Opperman says, that was invalid. You can't search my car. Tow it is one thing, but don't get into my car. And the Supreme Court says, hey, hold on. That's part of, good police work, right? And not in the sense of criminal activity, but that's part of just making sure that we are protecting ourselves, right? So the court said the Vermilion police were indisputably engaged in a caretaking search of a lawfully impounded automobile. The inventory was conducted only after the car had been impounded for multiple parking violations. Owner left his car, extended period, wasn't able to pick it up. Now, here's what they said. As in Katie, that's a prior case involving community caretaking. There is no suggestion whatever that this standard procedure was a motive or was a pretext concealing an investigatory police motive, right? So mindset matters, okay? So if your primary mindset, right, is to grab that evidence, just to go into that car and try to find a reason into that car and grab evidence, you got a problem on your hands. Now, however, hunches are okay, guys, okay? Nobody's telling you to be stupid and ignorant of what's going on out there, okay? Now, Lumpkin also reinforces an inventory search must be undertaken for the purposes of investigation and must be conducted according to standard police procedures, right? However, the fact that an officer suspects that contraband may be found does not defeat an otherwise proper search, right? Inventory search. So how did the courts kind of prove that you're up to something? The first thing is no community caretaking rationale, right? Many court cases around the country, including California, they require that the cops articulate a community caretaking rationale. They're not looking for, the law says I can tow it, it may tow it. They're looking for why. Like, why are you doing it, right? Why are you trying, who are you helping here, right? Yourself, your agency, the person. Tow called after a thorough inventory. What they're saying here is that, you look like you're doing a PC search, but you're calling it inventory. I've done plenty of inventory searches, and they all look very quick because I hate searching people's cars. I got to tell you, I hate dirty people, okay? So if you're a dirty person, I hate you, right? It's just the way it is, because in my career, I have searched so many dirty-ass cars that I'm tainted that I hate all dirty people. But when I'm looking for evidence, I put my biases aside, and I search the hell out of those cars because I ain't going to let the evidence go down the street. Do you see my point, though? The way I search the car and the way you search the car is a little different when it comes to inventories and PC searches. One's way more thorough. Tow, not typically called for the same situation. Officer, do you normally tow cars just because they're 2 weeks expired? Well, not really, Your Honor, but sometimes. Area search not typical, policy not followed. Probably, my friends, the most damaging case, the most mic drop of a case to prove what we're talking about here, Zach and I are talking about here, is State versus Crawl. Okay. What happened here is North Dakota police officers are interested in finding drugs in Crawl's car. Okay. And based on their investigation and what they say on the microphone, the body worn camera, and what they say this and what they say in that, they pretty much prove that they are all about, getting into Crawl's car, whether he likes it or not. So they don't have consent, they don't have probable cause, but they have this hunch that there's drugs in Crawl's car. So they used the law allows them to tow the car, for the right reason, but the court proved that they were not doing it on the up and up. And when they popped the trunk, what did they find? What did they find? They found a raped and murdered woman. It was actually Crawl's roommate that this POS, okay, complete POS, murdered, okay, raped and murdered, okay? And because the officers, unfortunately, did not know the rules of the game, that body is going to be suppressed. And Crawl literally got away with murder. Let me see, I think I might have a quote on this case. The court said, an inventory search is not an exception to the warrant requirement if it is carried out in the midst of a criminal investigation and there is no evidence the police were concerned with protecting or safeguarding either their interests or the owner's property interest. And this case was upheld, the suppression of the body, by the North Dakota Supreme Court. Now, let me tell you something, my friends. We're talking about North Dakota here. We're not talking about some extreme left-wing judge in Illinois, California, LA, New York. We're talking about good old North Dakota, right? Where they love their cops. If they're saying no, you can't do this, what do you think, right? What do you think your courts are going to say, right? So this is the right answer, okay? It's a very sad outcome, but Zach and I and all our instructors at Blue to Gold, we have been teaching this for years to not taint the motor vehicle. I'm sorry, do not taint the inventory exception. Be on the up and up, man. And you know what? If you don't got it, you don't got it. If you don't got probable cause, you don't got consent, you don't have a drug dog for reasonable suspicion, just let it go and let's get him another day, right? All right. My question for you, did you find this information useful? Yes or no? Show me some love here. You can hit the heart button, the the hand button. So Bree Lynn is here. If you guys want or interested, this actually says Aaron Martin, but we also have Mike Arena. I'll also get this fixed. I thought were all fixed. But we have Mike and then Aaron. We have Bree Lynn. We have a great team over here. Guys, please, please, please email us at training@bluetogold.com if you want to bring us in. Our schedule's a little tight, so maybe if you're interested in bringing us in, definitely get on the horn with our folks. Also, definitely reach out to us on social media.